comes for the first time, an auction has been notified. I'll tell you why. Their attempt to paint me a defaulter, I'm the one who's cheated. I'm not a defaulter at all. Mr. Dhruv Mehta's client, the IRP, will apply for clarification.
This liquidation proceedings, there's no IRP or CIRP.
Very well, that's the best semantic point he has. It is a liquidator. I'm sorry, my apologies. Liquidation assets. That means you are not liquidating them in the CIRP. But the shareholding is being made into a bone, into a hollow shell. That you can't do in terms of 35(1)(d) where you must protect the. That's what I'm saying.
This argument falls in the teeth of the foundational principle of corporate law.
Completely flawed understanding, my lord. Expression of interest, my lord, I will show. Made it very clear, my lord. Is the company in liquidation, my lord, sold as a going concern?
We are not permitting Dr. Singhvi.
I'm not a defaulter at all. Nevertheless, with prejudice, just
No,
to show
you
my.
did not pay the amount.
Yes, therefore, Malas, I will pay the amount here. I offered to pay it in escrow earlier. They refused. Allow me to show I've made, Malas, the whole matter I'll argue on 2 pages, Malas. One for one point, the other for the. Your Lordship will be a little shocked.
What is the balance
How
amount?
I've been taken for a ride. But let me give you the issue. The amount is knocked down to me on a third auction after 2 failed auctions at 1200 crores. As required in the initial earnest and later I pay 150 crores.
Yes.
After 150 crores, I point out to them that in this one sheeter, there are 8 places where it is clear that I, the CD, which I'm getting, I'm the SRA in a CD, has the shares 100% of a subsidiary. They must remain there, and the subsidiary, which will be remaining a separate subsidiary, 100% shares come to me. I state in the CRP process 8 times. They agree in the business plan, which they rely upon. My business plan says so. They then say there is some confusion in the order, which does not indicate whether the shares will come to you or not. So we, that is the Mr. Dhruv Mehta's client, the IRP, will apply for clarification.
This liquidation proceedings, there's no IRP or CIRP.
Very well. That's the best semantic point he has. It is a liquidator. I'm sorry. My apologies. I hope that's not the best winning semantic point. So the liquidator then says, I will apply for clarification. The clarification he never applies for. Meanwhile, the 100% shareholding, which is in 8 places in writing accepted by them, some of the banks, the respondents, start stripping away everything and they sell.
On their own. They go on their own.
Selling. So I say that, look, even though you are stripping away my asset on which I bid, when I bid, Malas, I take the total value. I will still, Malas, pay in an escrow the balance amount as required. In writing, they refuse. Now, what am I to do, Malas? 12 and not a small amount. I paid 150. I'm putting the balance 950, etc. or in escrow. I'll put it here before your lordships. They say no. Now, see those pages. Give me 5 minutes.
Now, what is the date for the
auction is notified for today. Auction notified for today, Malas.
Your entire argument
Yes.
goes against the provision of law.
Therefore,
Section 36
on the contrary, I will show it in my favor.
specifically speaks of the assets of the liquidation asset of a company going into liquidation.
So I will show the provision in my favor. Contrary
The
to
assets or the shares belong to you,
my lord is
but
right.
the assets
Yes.
of the subsidiary or
Now, exactly. This is the
the
error.
holding
This is
company
the
will
error.
not.
Your lordship is rightly in the impugned order. They rely on that section. There is another section which says all the assets and estate of the subsidiary will come in the CIR. Now, wait a minute. I am not wanting to take assets of the subsidiary. I am saying if I own 100% of the subsidiary, you can't hollow out the subsidiary.
There is a difference between
Yes.
the assets of the subsidiary
Yes.
coming.
Yes.
That is to find the net present value
For which I
of the
bid.
company which is going into liquidation.
Which I am bidding for.
Which will be the SRA, as you say,
I'm
will come
grateful.
up.
I'm
But
grateful.
this is not a case of SRA. It's not a case of a resolution plan under section 31.
With
There's
respect.
a difference between a resolution plan of
what is the reason for cancellation?
So therefore,
36.
cancellation either I didn't pay the balance. I am saying you
because
can't
he's
strip
not
the assets.
satisfied.
No, let me answer my
You
lordship.
could have deposited it.
Now I write to them. Please take it in escrow. He says no in writing. Give me a minute, please. Let me answer my lordship's Baki's query. There is a section which says specifically subsidiaries included. My lord says for NPV is the value I bid for. So this is the subsidiary.
You don't bid for NPV.
No, I bid for the subsidiary.
You bid
For the
post
CD.
liquidation on the e-auction notice.
Yes.
And the e-auction notice clearly says X company.
So let me show 2 things, fellas. The point is that when I bid for a CD which has a 100% subsidiary, I don't want the subsidiary. But while I am getting the 100% shares, you cannot hollow out the subsidiary by selling everything in the subsidiary.
It's a
That's the point.
debatable question.
That's what.
But let us go into the most simpler one.
Yes.
That you have put in the escrow account and you are proposing to put in the remainder of the.
Yes.
Of the account.
To show my bona fides
Bona
here
fide.
to your lordship. Give me 2 minutes more. I want to show not only.
So let us.
No, but your lordship
on
is
that
trying to issue notice. I appreciate. But
call
lordship, you
upon
see
the
this.
liquidator
Just
to
1 minute.
respond.
Well, just 2 minutes more. So notice is required for that reason. But in addition, just see this page. My point is a little different and slightly nuanced point. Para 2. And remember, I am the third sole bidder after 2 auctions failed.
Are you putting in this amount on the premise that this is only in respect of the assets of the liquidated company?
No.
Or bid.
Then we don't think
No,
we should.
I'm not even saying that. The bid is for 1200 crores. That bid has a listing which is in para 2. Just see para 2 minutes. Para 2. A to H is 8 items. In writing 8 items from the beginning of the auction to me says that the entire estate will be covered. Now I bid. The bid after my bid, this is the subsidiary whose 100% shareholding I own. While the bid is pending, they hollow out the subsidiary by selling. I say, don't do it. I want to pay the money. Don't hollow out my subsidiary of which 100% shares
No,
I
the
own.
value included that of the
That's
subsidy.
these pages. Just come to this page. Now just bear with me. Auction 2A. Just as Bakshi will have 2A also. Auction notice. That is the
So the
inception.
1200 crores included that also.
This is the pages I am giving.
Subsidiary.
The auction notice on inception on 20th November. And your lordship knows they have a VDR in the virtual data room in IS process. They include the details of subsidiary, exact pages given. Then this is the most important. B is the most important. In the B Malaz, I give a business plan where copiously at page 87 and 96 I say, I look at the value there also only of shares. My Lord Justice Bhakti is right. I am not trying to take away, but my share value.
Details of subsidiary is the share value of the subsidiary.
That's all I want. My point is, how does the share value remain if you hollow out the subsidiary? How does the share value remain if the subsidiary?
Singhvi, the share value of a subsidiary
Yes.
depends on the degree of encumbrances of the assets of the subsidiary.
But very well, let me accept that. I will take
You just say, I have substantial
with
immovable
encumbrance.
property,
With encumbrance.
but we have got it with a bank. And then will the share value not?
No. I am taking the encumbered share value. I am on a different point. While I am paying, you can't sell away the encumbered asset.
That is
If you sell it away, nothing is left.
Sir, in doing that, we are reaching out beyond the corpus of the company which is in liquidation. We are going into a third party contract
Only by 100%.
between another subsidiary and a
I
financial.
am having 100% shareholding.
What is the reason for cancellation?
Yes.
Only because
Yes.
you did not
You
did not deposit.
Answer that. I wrote to them in just C, my business plan is B. In C, he says, I rely on your business plan. The other side says, rely on my business plan. D, he says that follow the business plan scrupulously. Give me a minute. NCLT order says that, judicial order. E says that liquidator will seek a clarification. Liquidator, E. He never seeks. F, forget F, G. On 15 November, he seeks clarification. Liquidator never seeks clarification. The meeting says seek it, he doesn't seek. H, again I repeat. Now, I write to them, this is very important. And 4A, this is Justice Nagapta's queries answer. 4A, I say I can't pay you in the blank as much as 900 crore without knowing what is happening. I'll put it in escrow to show my bond. That's 4A, page 308 and 309. My lord has got it? Yes. Justice Pachi has got it. And they refuse in writing, saying there is no provision for escrow. Now come to the last and most important point. Just turn to this. Read these volumes. I'm only saying I will show my bona by putting it in escrow now before your lordships. Give a copy to you. What are they doing? Just see this. What are they doing? Take this index. Please give it to my lords. Now, what they do while under my nose is just see the index alone. In item 1, index of this volume. In item 1, they sell off. This item 1 is ownership of 355 acres by me. So that also will leave. I am the CD. Come to 2. This is the subsidiary's ownership of 1670 acres. Justice Bakshi may kindly give me a minute on this. No, not on this, but on the index of this volume.
This one.
While I am offering to deposit your escrow, you are doing this, saying I can't accept your escrow, plus I will do this. Well, let's come to number 2 is 1670 acres which is 82% of the total of 2025 acres, is sought to be sold by these of the subsidiaries land. I'll show the chart in a minute. That is item 2. Then item 3 is 551 acres out of the same is sold with the 3 ABCD I have given Malas. 3A and B gives the details of the sale. 423 acres and 123 acres. Notice of sale are given. And last is most important, next page 4. They sell 275 acres in item 4 from all these banks. Now what I am only saying is, I will put the money. I have 100%, my lot says, I must show my bona fides, I cannot bonus run it. They should stop this
Singhvi.
sale.
Now all these sales have taken place.
Auction notices are given, we don't get details. I am banging my head asking.
Whether these sales have taken place.
Auction notices are attached. I don't know sale or not, they can tell you. Auction notices are attached.
They are already passed. We have
They
passed
would have
those
failed.
dates.
Well, auction notices would have failed. This my own auction is third time lucky. Why should you want to do this? Please test my bona fides. And well, just showing your lordship that other provision. Well,
There's a huge company that taking assets. Even I don't know. What is the assets of those companies?
one more sentence. Justice Bakshi rightly had a doubt about the provision. Just see two provisions. Lordship should be clear on the law. 36 3D of the Act. Kindly just bear with me. Justice Nagarata may take 36 3D of the Act.
3D and 4D have to be read together.
And one more, 35 1D. Just 1 minute. I'll show. Just 1 minute. There's one more very important. 36 3D. Subject to 4, the liquidation estate shall comprise all liquidation estate assets which shall include the following.
Right.
Does Justice Nagarata have it?
Yes.
Now come to D. Intangible assets, including but not limited to intellectual property, securities, including shares held in the subsidiary of a corporate debtor. I'm only concerning shares and financial instruments. Now, Justice
So
Bakshi, right?
what prevented you from at least depositing the amount with the
Please see my letter.
permission of-
Please see, I wrote in writing.
No, not writing, depositing. You could have
How
deposited.
do I deposit
before
without
the
some protection? Tomorrow it never comes.
Tribunal also you could have
I
deposited.
write saying put it in escrow. Well, practically, will your lordship expect a businessman to put 900 where he may not get back anything? Well, your lordship has no protection at that time. I put it in
Now
good faith.
what prevents you
Except-
from participating in the auction? You
I
could have
beg-
felt again.
No, they've
With
got
regard to the
150.
corporate debtor.
They've got 150 crores already.
Yes.
They've already got 150.
Yes.
4 years. I was the third sole bidder. They failed 2 auctions. I am prepared to put today. They should defer the auction and test my bona fide. Lordship will decide this second section. Just see 35 1D. The previous Lordship has not seen that. No, well, 35 1D says this liquidator in the statute 35 1D is the previous, not 34.
Yes.
The liquidated D minus 35 must take such measures, when the provision starts, following powers and duties.
Yes.
And D is to take such measures to protect and preserve the assets and properties of the corporate debtor. Now, properties, shares, that much well is there. Now, your lordship will reconcile D, 4D, which my lord Justice Bakshi mentioned. 4D does not mean this, fellows. It means the following shall not be included in the liquidation assets. That means you are not liquidating them in the CRP. But the shareholding is being made into a bone, into a hollow shell. That you can't do in terms of 35 1D where you must protect the. That's what I'm saying.
Argument falls in the teeth of the foundational principle of corporate law. A shareholder is not.
Bacha Gazdar. Bacha Gazdar.
Yes.
I'm
The
not,
shareholder cannot be said to be the owner of the company's
therefore,
assets.
I am not arguing that.
What the shareholder may do
Yes.
is direct
But
the
sir-
company in the manner in which the assets are to be
So now,
managed, etc.
let me accept that principle.
So for
Does
that,
it mean
you have to take a decision in the board of that subsidiary.
correct? But does it mean, Malaz, that 100% owner of the SRA will allow the subsidiaries go? I'm not questioning Bacha Gazdar. I don't want to sell the assets. I don't want to control the assets. While the principal is
are
sitting.
one with you if you decide that you will put in that escrow on the clear understanding that it is the shares of the subsidiary and not the assets of the subsidiary. over
I'm
which
saying,
you are-
I'm reading the section to your lordship. Shares. I cannot.
shares of the
Because
subsidiary.
I'm saying, Malaz, I'm not on Bacha Gazdar. I'm saying, while the owner of the
That
shares
is what we are
sitting.
saying because that will run squarely against.
Well, I did the
primary
second case
principle.
which followed Bacha Gazdar later on.
You can take that
Absolutely.
one.
So I am
One
saying
thing you can withdraw and.
protection is required. I will put it here, Malaz, in the escrow.
No.
Your lordship
the,
protection.
the wiser option is
Listen now.
that the wiser option is that 150 crore you can take
You
back.
take back the
There's no
150.
question of forfeiture and you participate afresh.
I understand.
Wiser option.
Yes.
That's a better.
Take back the one.
Take back will permit you, though there is a difference of opinion there on that 150.
You want to argue this, right? That's also.
What is the lordship, Malas, if I may have
That
the liberty of
150 is
asking
the
the
difference of
second
opinion.
option, Malas, if I may have the
And
option?
you participate in the auction again. It is going to be
No,
held.
that is option one, that I take back and participate anew.
Yes,
Malas,
that is the only,
if I deposit the balance,
There is a difference of opinion with
If I-
regard to the forfeiture of
that's
rupees.
pending.
We will permit you to take it back.
Yes.
And then you participate
I
after.
appreciate. Can I suggest this, Malas? Since I'm there with my foot in the door for so many years, I deposit the balance here in the escrow. Your lordship considers the matter on law and then decide.
You're taking a bigger risk there. Because all this litigation is there still.
Dr. Singhvi, we are not really
The
pressed
uncertainty
on a
is-
prima facie case in law. So what we feel, we understand there was some confusion and you may be given the equitable benefit of refund and participation.
Please hear me, my lord, because on the
We will
issue,
hear.
yes, my lord.
That 150 will
My
permit you.
husband is
to
adding
take it.
one more. Suppose I participate, as my lord is saying, I have after all an equity of a person with 150 for the last 4 years and ready to pay. I participate, I withdraw that 150, that forfeiture goes, I participate. Your lordship may consider this happens frequently, that if there is by chance a person higher than me, I am given a Swiss challenge right to match him. I am the person with the skin in the game.
That you can always.
That will be dependent in the
What happens,
auction process.
what happens after
It's
the
a
auction?
dependent auction
Yes.
process, let it be kept open.
We'll say all your remedies are open. All remedies are open.
So give me a minute.
Your remedies will be open, having regard to the fact that you had earlier been the highest bidder.
Would your lordship?
You had been the highest bidder. We will keep all options open for you.
Well, can I just come back after the next matter? The person is not here apparently. I can't take a responsibility myself. May I interrupt the
Mehta,
next
you are-
matter?
Lord, I pay for the liquidator. I have something to say, my lord. because-
About the
Refund.
That's right, because your lordship of prima facie not
No,
inclined
now
to the
there is
merits
a-
of the matter.
After all, he had put in this money, he
And he
makes
was the
case
highest
that
bidder.
there was a business plan which had been deliberated
I want to
upon.
say something on that, my lord, because it's a completely flawed understanding, my lord. Expression of interest, my lord, I will show. Made it very clear, my lord, is the company in liquidation, my lord, sold as a going.
We are not permitting Dr. Singhvi to admit this petition on that question.
No, I'm on the
But what
refund.
we are saying is, as
Refund.
an asset,
I mean, my lord, the
See, you should
terms and
not-
conditions.
and
You
if
cannot also
out of
ignore
the
the
two-
uncertainties that he was facing. The
The
uncertainties.
uncertain- no, that's a
See,
flawed
you-
understanding.
No, a prudent businessman will not,
I'm
see,
sorry.
risk 950
No,
crore
my
when
lord,
there
with
is.
great respect, it's a flawed understanding on
Yes,
their part.
yes.
Then please consider it. Have the auction after 2 weeks.
No,
Consider
no.
the matter.
For-
Let the auction come after 2
No,
weeks.
not that. The fact remains that one of the judges agreed for refund.
Yes.
But
The
can I-
other,
but can I-
that therefore.
on
we
cancellation, he concurs on cancellation. The
Correct.
technical
We
matter
are
says
not
cancellation.
interfering with cancellation.
Correct.
We are permitting them to withdraw
I
that
understand,
150
but
and liberty to
Not
participate
lost
in any.
That's it's a full
Lord,
justice.
with great respect, my lord. Lost, my lord, we have
No, no.
filed- please remember. we have
See,
filed down the line.
there is
And
uncertainty
we have
created.
spent on this litigation.
There is uncertainty created on this side.
No, that's
Yes.
what I want. No, I'm sorry.
So,
My lord, with
which
great respect.
prudent businessman will risk 950 more
My
crore
lord, that is what, my lord,
with so much of
the
uncertainty?
order passed by NCLT, my lord, in 2024 said it's your flawed understanding.
That
And the statute is very
I'll
clear.
be very frank. I don't have instruction. Foolish is the person not here, but I will agree on my own risk.
No, on merits, we
No,
will.
I will agree on my risk.
On
I
merits.
will agree on my risk.
But not on refund, your lordship will hear us, my lord.
No,
I think it's a very fair point, Manoj. It's
Just
just a
kindly
point.
consider.
Let there be a hiatus on this.
yes.
It's a-
See, then the
All right.
discussion will continue.
And we
You
have
go,
to start-
go on a clean slate. You go on a clean slate for the next auction.
Well, I want to be clear in the order, Malas. Your lordship will allow the 150 to come back.
With
I
respect,
bid on the same
he's
terms.
actually succeeding, my lord, after losing all the blood.
No.
at
Why
every
does he want
stage.
somebody else to
There
get
He's
it?
getting the money
Why does he
back.
want
See,
commissions to
if
get
we
it, Malas?
say, let him, today if we issue notice and ask him to deposit
Yeah, for
90,
this.
you can say it's a success. He's not, we are not saying that today.
No, but this is going against the terms.
See,
Why does he want
uncertain-
someone else?
See,
I'm only a bidder.
See, if uncertainties are created for an investor like this, what can any investor do?
Please ask the question, why does the IRP want another bidder? Why can't he have me along with the other bidders?
Respect, my lord, let me now respond to this. I'm only on the refund.
No, we'll issue that.
Just, my lord, just kindly consider, my lord, the lordship, it's a lot, ultimately 5 years have been spent on this litigation.
Why should you also be benefited
Mr.
doubly?
Mehta,
Yes.
the way you are arguing,
Why is he
you
looking-
are generating another 2 years on the refund.
And
All right.
it's sitting
So
behind
So
paragraph.
please,
If we
please
go into the
understand
minutes,
the commercial sense with which we should approach these problems.
you
Going
see,
against the statute.
go, please see the,
36(4)(d).
please see the judgment,
on that.
Justice Puyan and myself, we have given one judgment, we are not adverting to it, where the liquidator's right or powers of cancellation, we have questioned that. Under what circumstances, see the judgment,
Lord, I have only gone by the terms.
I think 23,
Clause 10.5, just have a look at clause
Justice
10.5.
Puyan's
If
judgment.
you don't, my lord, deposit,
And myself,
it's liable for cancellation.
Liquidators, powers of cancellation,
Not
if we
in that
advert to
sense,
that,
He refuses in writing for escrow at page 332. He says, don't deposit.
Matter.
Very unfortunate.
All of you know that these forfeiture clauses
yes.
subject to section 23 of the Contract Act, 73 and 74 of the Contract Act. So you cannot have
Reasonable.
a unequivocal forfeiture always. There must be a situation where the adjudication would be of the extent to which the party who deposits and the reason for deposit and the forfeiture default.
Bow down to that.
So there should be a forfeiture default.
I-
So instead of going into that question, if we allow Dr. Singhvi's plan to take back
Withdraw that.
and the auction be held on a clean slate.
And I'm
he will
another
take
bidder.
unwitting
For him, I'm another bidder. Why should
Actually,
I
the lenders will be at loss, my lord. I am the liquidator only. The lenders will lose because
Very
there are
sad line.
about 15 lenders here, my lord.
Earnest money
15.
deposit is 50 crores.
Then you go ahead with the present auction.
Number
Let
two,
them deposit the 950. If you want to save that
I'm not
150,
saying- I'm
we
only
will
saying
ask
the
them to
lenders are
deposit
losing
that
money.
950.
I'm only
And you
the
go ahead.
liquidator. I'm only-
You can't have it both ways.
No, I'm not saying that. I'm only saying the lenders, my lord, are the losing
Yes.
ticket, my lord. There are thousands
After all,
of
Why
one
is
of
he
the
concerned,
members-
Madas? Why is he
After
concerned?
all, one of the members agreed for refund of 150.
we have just add one sentence, Millers.
Other
Because
than
please
you
look
do-
at Millers the timelines for a moment. Millers, 15th of December
Who
21.
created the uncertainty in
Yes,
this
we
matter?
22 he refused escrow. In 2022
on
he
an
refused
as
escrow.
is basis. There was no ambiguity in the Millers auction notice.
That is why we,
On an as-is
that
basis.
is why
One.
we put a full
15th
stop to
December
this.
21. Millers, the statute prescribes 90 days. After which, Millers, the sale has to come to an end. The statute prescribes 90 days for payment. Despite that, on Millers,
Where the tribunal has extended the time.
Millers from 22 June till
In fact, they
23
made
June.
applications for
And
extension.
Millers,
I made extension. He refused escrow. The
Millers, with
tribunal by
utmost
judicial
respect,
order extended
the
time. Didn't
escrow
challenge it.
request is of 22. After that, he doesn't move a finger. Now, please look
Now,
at the
even
timeline.
by your argument, sir, your right of forfeiture may extend to earnest deposit, not to an installment deposit. Only 50 crores.
That's right.
EMD is 50 only, my lord.
No, 50
EMD is
plus
50,
100 I
that's
paid
what
again.
point out.
I paid 100 more,
Yes,
sir.
100
Please don't
again.
ignore
That's
that.
150 crores
100
now.
crore may be nothing to
Because
do.
that
Not
is
for me.
part of
No,
that.
I only got the
You
EMD
can't
is
forfeit
50.
part of the sale price. You might have a case of forfeiting
That's-
50
I am
crores. So
sticking to 50
why
only.
unnecessarily
No,
going
no,
to
I
this
am-
150
Sorry, my lord, perhaps I've been misunderstood.
Earnest money,
My
only
lord,
earnest
I'm
money.
not-
Yes, 150.
I'm
they-
on this earnest money. I was never on the 100 crores. I was only 50
So
crores.
now it goes down to
No,
50
no,
crores.
150 is the EMD.
Otherwise, let him defer the auction till July, hear the matter and let it.
150 is what you have deposited.
Yes.
Totally.
Yes.
That can be.
Ma'am, what do you think?
50 is the earnest. 100 crores for the installment.
Under installment, exactly.
Your client is madder than you. No, I'm telling you, you will never understand. It's not okay.
50 crores.
Fantastic thing. You
Yes.
won the matter. You don't realize I'll tell you outside. Well, by the way, I'm sorry. I
Absolutely.
should have added. Your Lordship's judgment, para 42, has an interesting paragraph about the conduct of a person like Mr.
Ah,
Mehta.
it's a liquidator.
Nobody's commented
No,
on my
which is
contact.
the name of
Yes,
the
yes.
See,
We
and
see the-
they have
we
said,
forget
Malord,
the-
I'm not
Yeah, yes,
responsible.
what is the-
They now, Malord, send my contact, my contact.
No,
My fault. My
No,
clear should have got it.
please refresh us on the
Thus,
cost
mere
type.
cost title is Eva Green. Eva Agro Foods.
Yes,
Dated-
Eva Agro Foods, correct.
And well, just that para 42.
Agro
Thus,
something we
Yes.
remember.
Eva Agro.
Malord,
Thus, mere
I'm
expect.
appearing for the new liquidator
Thus-
who's appointed in 2025, Malord.
But he's
I
fighting
pay for the
harder
new
than the old
liquidator.
liquidator. Thus, mere expectation of the liquidator that still a higher price may be obtained can be no good ground to cancel an auction, otherwise valid, and to go for another round of auction. Such a cause of action would not only lead to incurring of avoidable expenses, but also erode the credibility of the auction process itself. Post auction, it is not open to the liquidator to act
CLA.
on third party, etc. Next sentence, the necessary corollary that follows is there can be no absolute or unfettered discretion on the part of the liquidator to cancel an auction. As it is an administrative
Dr. Singhvi, come to page 75 of the impugned order, it's considered by NCLA. Paragraph 73. Agro.
Page 74.
What-
So,
Considered, so we'll rest it.
anyway,
at
Manoj, I don't want to get into those. May I just summarize in one sentence? There are three options, subject of course to my Lord's discretion. One is, I believe an equitable, justice-oriented approach. I take back all the money and I rebuild like anybody else, and may the best man win. Alternatively, I will deposit the rest in escrow. Lordship defers this option and hear the matter in July. That's a fair thing for us to do. And thirdly, if I bid for Mr. Mehta, I am nothing but another bidder. He should have no preferences amongst bidders. Exclusion will help anybody, Malas. If you have three bidders, in this matter, Malas, there were two failed auctions. I came the third time. If you have, Malas, three bidders instead of two, or four instead of three, it benefits only Mr. Mehta and my learned friend. Who does it benefit? Doesn't benefit me. So, Malas, why should you object to this? Otherwise, the Lordship hears it in July, let them defer the auction.
We have heard Dr. Singhvi for the Learned Media Council and Learned, you are for the respondent number?
They are
For the
Learned
liquidation.
Media Council, Sri Dhruv Mehta for the respondent.
I pay for the
Liquidator.
liquidator.
No,
Yes,
And
R1
Learned
is
Media Council,
R1 is
R1.
R3 onwards are the FCs.
yes,
Financial.
I was 7.
yes, for the respondents, other respondents. We dispose of this civil appeal by directing that the sum of rupees 50 plus 100, totally 150 crores that has been deposited by the appellant with the official liquidator to be refunded and released to the appellant within a period of 2 weeks from today.
Lordship is like.
Within a period of 2 weeks from today. Since we are not,
If we take a little Lordship, there are several lenders here, because Lordship, then it would have been distributed to
4
the
weeks
lenders.
from
Very well,
today.
4 weeks.
Since we are not otherwise interfering with the impugned orders, we permit the fresh auction to take place and reserve liberty to the appellant herein to participate in the said auction in accordance with law.
It's today, so just add a word.
It is today only.
It's today, no? Today or not, according to them, unless they extend it. It's today.
We don't know
Because
about.
just say, I submit that its last date was today, so I'll be participating.
Today you will participate.
Yes.
At this stage, it is brought to our notice that the auction is fixed for today. Put the date, today's date.
Today or not.
Therefore,
You go and pick.
the aforesaid liberty shall inure to the benefit of the appellant herein, ordered accordingly.
I'm told, my lord, it's been extended, my lord.
Whatever,
So there is no delay.
in case it,
Or
Or
extend.
such other extent.
Or such
Lordship
extent.
may say now the divergence issue
or
is not to be
such
gone into now.
extended-
Ah.
We are already passing an order.
Yes.
The hiatus on that.
As my lord is saying, or such extended date.
therefore, it's not necessary to go to the chairman now.
That's exactly, your lordship may just say that. Your lordship may just say now that it's become unnecessary.
Added.
Yes, in view of the aforesaid direction, the reference of the difference to the chairman would not be, would wholly be academic now.
Deeply obliged. Very deeply obliged.
I was only on the EMD, my lord. I wasn't on the 100 cross.
Therefore, we put 50 plus 100. we put.
But then we are not
Therefore, we said 50
But
plus
the funny thing
100.
is, my lord, 4 years have been spent.
small mercy.
Yes.
Small mercy.
Start the
Start on a new slate, clean slate.
दोस्तों ये था इस बड़े कॉर्पोरेट विवाद का पूरा कानूनी मामला। दिवालिया कानून के तहत संपत्तियों की नीलामी और अधिकारों को लेकर माननीय अदालत में बेहद अहम और बारीक कानूनी बहस चल रही है। माननीय अदालत का जो भी फैसला आएगा वह देश के बिजनेस और कॉर्पोरेट जगत के लिए एक नई नजीर पेश करेगा। दोस्तों आपका इस बारे में क्या कहना, अपनी कीमती राय कमेंट्स बॉक्स में जरूर साझा करें। जय हिंद दोस्तों।